Committee members, I would ask everybody to take their seats as we are about to begin. The clerk has advised me we do have a quorum, and those members that are appearing virtually have been tested. It's an easy test today. They're at the back of the hall. Okay, and there is some members appearing virtually. We welcome some replacements on the committee today. Mr. Malillo and Madame Kuzi is back for a while, and Mr. Maurice is joining us as well. So I will call the meeting to order. Welcome to meeting number 49 of the House of Commons Standing Committee on Human Resources, Skills, Social Development and the Status of Persons with Disabilities. Today's meeting is taking place in a hybrid format pursuant to the House Order of June the 23rd, 2020. Members attending in person and remotely using the Zoom application. To ensure an orderly meeting, I would like to take a few moments for the benefit of witnesses and members. Before speaking, please wait until I recognize you by name. For those participating virtually, please use the raised hand function. Before speaking, click on the mic icon. You have the option of choosing to speak in the official language of your choice. I would ask everybody to speak slowly for the benefit of the translators, the interpretation services. And if there is a breakdown in translation, please get my attention. We'll suspend while it's being corrected. Bill C-22, the Canada Disability Act. Pursuant to the order of reference of Tuesday, October the 18th, 2022, the committee will resume its consideration of Bill C-22, Canada Disability Act. Before we begin clause-by-clause consideration, I would like to provide members of the committee with some instructions and a few comments on how the committee will proceed with the clause-by-clause consideration of Bill C-22. As the name indicates, this is an examination of all the clauses in the order in which they appear in the bill. I will call each clause successively, and each clause is subject to debate and a vote. If there are amendments to the clause in question, I will recognize the member proposing it, who may explain it. The amendment will then open for debate. When no further members wish to speak, the amendment will be voted on. Amendments will be considered in the order in which they appear in the bill or in the package each member received from the clerk. Members should note that amendments must be submitted in writing to the clerk of the committee. As chair, I will go slowly to allow all members to follow the proceedings properly. Amendments has been given an alphanumeric number in the top right corner to indicate which party submitted them. There is no need for a seconder to move an amendment. Once moved, you will need unanimous consent to withdraw it. During debate on an amendment, members are permitted to move sub-amendments. These sub-amendments must be submitted in writing. They do not require the approval of the mover of the amendment. Only one sub-amendment may be considered at a time, and that sub-amendment cannot be amended. When a sub-amendment is moved to an amendment, it is voted on first. Then another sub-amendment may be moved, or the committee may consider the main amendment and vote on it. Once every clause has been voted on, the committee will vote on the bill, on the title and the bill itself, and in order to reprint the bill may be required if amendments are adopted, so that the House has a proper copy for use at report stage. Finally, the committee will have to order the chair to report the bill to the House. The report contains only the text of any adopted amendments as well as an indication of any deleted clause. I would like to welcome back to committee, and they're available here to answer technical questions related to the bill. We have Alexis Conrad, Senior Assistant Deputy Minister. Welcome. And we have Krista Wilcox, Director General, Office of Disability Issues. And I'm going to ask, with me today is Legislative Counsel, who will direct us on the legal, technical language of amendments and the clause of the bill. So I would ask them to introduce themselves.
Thank you, Mr. Chair. I'm Émilie Tivierge. I'm a legislative clerk, so I'll be there to help the committee with any question on the admissibility of the amendments.
Good afternoon. My name is Philippe Mella, also legislative clerk, and Émilie will do a fine job answering your questions.
Thank you. So clause by clause consideration.
Chair? So a couple comments, if you don't mind. First off, obviously, the quicker we can get this bill passed, the quicker that we can, move it forward. And just of note, there was 146 submissions. I know we all wanted to get the submissions. 146 submissions. Only 11 of those submissions called for amendments. 92% of those submissions didn't call for amendments. And we had 135 witnesses who did not call for amendments. So I recognize we're anxious to go through what we got here now, and we're anxious to get through this and get the bill back where it should be moving forward. Thank you.
Thank you, Mr. Long. Excuse me. Now, pursuant to Standing Order 75-1, consideration of clause and of the preamble are postponed. The chair calls Clause 2. Clause 2. PV1. Okay. Before we get to it, an amendment is deemed moved pursuant to routine motion adopted by the committee on December the 13th, 2021. So nobody has to move an amendment. For that reason, amendments NDP1 and LIB1 cannot be moved as they are identical to PV1. Shall PV1...
Sorry, I'd like to...
Sure. Mr. Morris, do you want to commentary on it's your amendment?
Thank you, Mr. Chair. Yes, so PV1 adds a definition of disability to the bill, and the definition being added in the word of the amendment has the same meaning as in Section 2 of the Accessible Canada Act. That definition is that disability means any impairment, including a physical, mental, intellectual, cognitive, learning, communication, or sensory impairment or a functional limitation, without permanent, temporary, or episodic, whether permanent, temporary, or episodic in nature, or evident or not, that in interaction with a barrier hinders a person's full and equal participation in society. And I'll just note that this was recommended by groups like the Multiple Sclerosis Society of Canada and Spinal Cord Injury Canada, and is identical, as you shared, to amendments being suggested by both the NDP and the governing party. Thank you.
Thank you, Mr. Morris. Mr. Kuzmarchuk?
Thank you, Mr. Chair. I just wanted to acknowledge the good work of our colleague here in committee, and it is an improvement. It strengthens this bill, provides additional clarity, and we will be supporting this amendment.
Seeing no further discussion, shall PV1 carry? Do you want to do a recorded vote on each one, or just and then yes? What's the wish of the committee? Okay. Ms. Gray?
There we go. I think for this one, we can just nod, but I would say for the entirety, we should have a recorded vote, other than perhaps this first one.
No, you're fine. If there is no disagreement, everybody's in agreement, a recorded division is not required. So I see unanimity on Clause 2, Amendment PV1. Carried. Shall Clause 2 carry as amended? I'm seeing thumbs up. I view there's a consensus, unanimity, that Clause 2 shall carry as amended. Clause 3, PV2. The amendment is deemed moved pursuant to the routine motion that was adopted by the committee, as I indicated, in December 13, 2021. Bill C-22 establishes the Canada Disability Benefit to reduce poverty and to support the financial security of working-age persons with disabilities. The amendment seeks to extend the benefit to persons with disabilities regardless of whether they are of working age. As House of Commons Procedure and Practice, 3rd edition, states on page 772, since an amendment may not infringe upon the financial initiative of the Crown, it is inadmissible if it imposes a charge on the public treasury, or if it extends the objects or purposes or relaxes the conditions and qualifications specified in the royal recommendation. In the opinion of myself as chair, the amendment seeks to alter the terms and conditions of the royal recommendation attached to the bill as adopted at the second reading by the House. Therefore, I rule the amendment inadmissible. Shall Clause 3 carry? Carried. I see unanimity. Clause 3 is carried.
Sir, Mr. Chair, can I just clarify? Point of order. So were we referring to PV2?
Yes.
Okay. So the clause just as it is carries? Then
Yes.
Without, okay, thank you,
Yes.
Mr. Chair.
Oh, sorry.
Thank
Yeah.
you for the clarification.
The amendment was ruled as
Right.
inadmissible.
Thank
You're correct, Ms. Gray. So shall Clause 3 carry? I see unanimity on that. Shall Clause 4 carry? There was no amendments on it. You all have Clause 4. Shall Clause 4 carry? I see unanimity. Clause 4 is carried. Clause 5, NDP 2. NDP 2, Ms. Cirillo, you have the floor.
Thank you, Mr. Chair. And this is actually the most important amendment for the NDP at this point in time to support persons with disabilities. The NDP believes fully that there is a lot of opportunity to involve the community, the disability community, in regulation, but here we'd like to protect the minimum income of persons with disabilities on this bill. So we have an amendment here that a benefit paid under subsection 1 must be sufficient to ensure that the person to whom it is paid does not live below the official poverty line as defined in section 2 of the Poverty Reduction Act. And Mr. Chair, you referred to page 772 of our House of Commons Procedure and Practice, and I note that it says in 772 around imposing a charge on the public treasury if it extends the objects or purposes or relaxes the condition and qualification specified in the royal recommendation. And we know within Bill C-22 there is actually no specified qualification in regards to the size of this benefit or the benefit itself. So I don't see it being in contradiction of page 772, since it has not been previously defined as a specific qualification. Thank you.
Thank you. Any discussion on the motion?
Mr.
Before we get to that, Mr. Kuzmarchuk, Bill C-22 establishes the Canada Disability Benefit to reduce poverty and to support the financial security of working-age persons with disabilities. It sets out generous provisions for the administration of the benefit and authorizes the Governor and Council to implement most of the benefit's design elements through regulations. The amendment attempts to change the terms of the benefit so that it is high enough to enable the person to whom it is paid to not live below the official poverty line as defined in Section 2 of the Poverty Reduction Act. As House of Commons Procedure and Practice, 3rd edition, states on page 772, and this is the interpretation given to me by the table officers of the Commons. I appreciate your interpretation, Ms. Cirillo, but I have to follow the table officers. Since an amendment may not infringe upon the financial initiative of the Crown, it is inadmissible if it imposes a charge on the public treasury, or if it extends the objects or purposes or relaxes the conditions and qualifications specified in the royal recommendation. In the opinion of the Chair, the amendment seeks to alter the terms and conditions of the royal recommendation attached to the bill as adopted at second reading by the House. Therefore, I rule the amendment inadmissible. This ruling also applies to Amendment PV3 since it is identical. So it's not okay. Ms. Cirillo?
Thank you, Mr. Chair. And I note the word generous benefit, but it was not qualification specified, so I'm going to go ahead and challenge the Chair. Thank you.
Okay, any member can challenge the Chair's ruling, but it's not debatable. My ruling is not debatable, so I will call clerk for a vote. Now what this is this is the ruling that's been provided to the committee by the House of Commons table officers. If the amendment was voted in, it would be unilaterally turned down when it gets to the House of Commons. But with that information, Chair, call a recorded vote on the motion by Ms. Cirillo to challenge the Chair on my ruling.
The question is, shall the decision of the Chair be sustained? If you agree, vote yes. If you disagree, vote no. Mr. Long.
Yes.
Madame Martinez-Ferrara.
Oui.
Mr. Collins.
Yes.
Mr. Kazmarechak.
Yes.
Mr. Van Bynen.
Yes.
Ms. Gray.
Yes.
Mr. Murillo. Yes. Ms. Kuzi.
Yes.
Ms. Ferrari.
Yes.
Madame Chabot.
Oui.
Ms. Cirillo.
No.
That's 10 yeas, 1 nay.
The Chair's ruling is sustained and the amendment is not approved. We move to Clause 5. Shall Clause 5 carry? I see consensus on Clause 5.
Yes.
Okay. Shall Clause 6 carry?
Yes.
Carried. Shall Clause 7 carry?
Yes.
Carried. Clause 8.
Yes.
No, we have PV for Mr. Morris.
Thank you,
Mr.
Mr.
Morris.
Chair. So PV4 seeks to add the words that the minister must make public any agreement entered into subsection 1. And specifically what this would do is it would require the federal government to make public all federal and provincial territorial agreements with respect to the Canada Disability Benefit. This was recommended by many groups, including the Accessibility for Ontarians with Disabilities Act Alliance, as well as experts who came to testify at committee like Mr. Prince, organizations like the Spinal Cord Injury Canada, and the Canadian Human Rights Commission. And I'll just note that part of the interest here of what I heard from the disability community is an interest in hearing from the government that this is about trust. And with more transparency, I think that leads to more trust from the people that this benefit is meant to serve. Thank you.
Mr. Kuzmarchuk on the amendment.
Well, thank you, Mr. Chair, and certainly throughout this entire process and working hand in hand with the disability community, our primary concern as well too. One of the priorities we had is to make sure that we build trust, make sure that we are transparent and working again side by side every step of the way. I do have some questions on this particular amendment to our officials, if that's okay. And the first question I wanted to ask, in the general practice in terms of federal, provincial agreements, can you speak to what is the normal course of action in terms of making those agreements public? And also, are there some agreements that are made public? Are there some agreements, for example, that are not made public? And what is the impact, or what could the potential impact be of requiring that all the agreements are made public? What impact might that have on the course of negotiations between the federal and provincial government and territorial governments, knowing that those negotiations are going to be so imperative, critical to making sure that we have the best supports possible for Canadians with disabilities?
Thank you. Mr. Chair, I would just maybe answer in a couple of ways. The first is that of the thousands and thousands, literally, of intergovernmental agreements that exist, a lot of them are public. Some by default, some are, upon request. So it's the general standard is, whenever possible, to release things publicly. There are times where governments prefer not to. I'll cite an example around compliance of a program. From time to time, there are details in agreements about information sharing and what information is shared between levels of government that if it was made public, it could lead to potential fraud, as people can understand the program better behind the scenes, and it could actually compromise the integrity of the program. So that's one thing. The other part is we generally, when we do a release agreement, seek provincial consent, giving us a partnership. We don't necessarily oblige them unless it's written into the agreement that it would be public. So in this sense, an obligation to release the agreement would actually oblige us to release something the province may not necessarily agree with.
Thank you very much for that. So knowing that this will be a complicated process, a negotiation, this amendment, in your opinion, does it have the potential to actually hinder the best outcomes of those discussions with our provincial and territorial partners?
Yeah, I think there is a risk that if we impose obligations on provinces or try to, that they will not see that in the spirit of partnership by which we've approached this. Minister's talked a lot about working closely with provinces as officials we are, and we've tried to do everything in the sense of partnership rather than put an obligation on the other party. There is a concern, or a risk at least, that the provinces would see that this is a break from that, and us trying to impose something on them.
Okay, thank you.
Ms. Gray on PV4 amendment.
Thank you, Mr. Chair. Well, I believe in open and transparent government, so I think this is something that we can support, and also considering that really almost everything in this piece of legislation is going to be in regulations. So in order for the public to be aware as to what actually has been agreed to, in particular, because everything will primarily be in regulations, it's important to be in there. So I'd be supporting this. Thank you.
Seeing no, Mr. Kuzmarchuk.
Mr. Chair, if I could just ask for a suspension of the meeting for a minute.
Sure. We'll suspend for several minutes, for 3 minutes. Committee will resume. And when we suspended, Ms. Gray had made an observation. Is there any further discussion on PV4?
Mr. Chair, I have a concern with respect to requiring these agreements to be disclosed. It may hamper negotiations, and there may be a requirement on behalf of the other party to have some degree of confidentiality. So I'm struggling with the notion of requiring people to do that. If in the normal course of events that there's a disclosure, I think that's appropriate, but there may be some situations where this could be a problematic requirement on behalf of the federal government.
Any further discussion on PV4? Any further discussion on PV4? Okay, Madam Clerk, since I sensed there's not going to be unanimity, I would ask for a recorded vote. You're voting on Amendment PV4. Shall it carry? We'll go to recorded vote. Yep.
The vote is on PV4. Mr. Long.
No.
Madame Martinez-Ferrara.
No.
Mr. Collins.
No.
Mr. Kuzmarchak.
No.
Mr. Van Bynen.
No.
Ms. Gray.
Yes?
Mr. Murillo.
Yes.
Ms. Kuzi.
I don't miss this. Yes.
Ms. Ferrari.
Yes.
Madame Chabot.
Oui.
Ms. Cirillo.
We.
That's 6 yeas, 5 nays.
So PV4 is carried. Shall Clause 8 carry as amended? I'm seeing consensus on Clause 8 as amended. So Clause 8 as amended is carried. Clause 9. So CPC 1, right? Yep. CPC 1, Ms. Gray.
Great. Thank you very much, Mr. Chair. And I'd like to move the following amendment, that Bill C-22 in Clause 9 be amended by adding, after line 25 on page 3, the following. Quote, Point 1 cannot be removed or recovered, rather, in whole or in part under any act of Parliament other than this act, and then it continues on with the rest. And what this is referring to, Mr. Chair, is around clawbacks. That's the intention of this. When we had gone to legal, this was the wording that was recommended in order to protect people with disabilities from potential clawbacks, and that's the intention of this amendment. Thank you, Mr. Chair.
Any discussion, Mr. Kuzmarchak, on CPC 1?
Yes, thank you, Mr. Chair. And obviously, all of us here, we're very much concerned with clawbacks, making sure, and it's something that we heard from pretty much every witness, if not every witness, to make sure that in negotiations, we make sure that there are no clawbacks in terms of provincial and territorial benefits that persons with disabilities already receive. I just wanted to get clarification, maybe from the clerk as well, too, in terms of the just in terms of this this amendment and the way that it's worded, because it could mean multiple things. For example, for some of us that reading it, it may mean, for example, that we cannot recover, for example, funds or payments in situations where there might be proven identity fraud, for example. So I'm a little bit concerned about the wording of this amendment. But I also wanted to ask our officials and basically ask them to maybe speak to what impact this might have on the Canada Disability Benefit. Do we foresee interactions, for example, between federal benefits, and whether this is the appropriate place to actually address that, or whether that can be addressed later on in the process through amendments in other pieces of legislation that provide for federal benefits. And so I'd like to explain that. And then I would also like a clarification, a third one, whether this amendment, as is written, whether it does safeguard, or excuse me, whether it does prevent the clawback of provincial and territorial benefits, because I know that was a primary concern for every witness that came to this committee and every submission.
And you're directing it to the officials? No. No, it's the officials will have to legislative council.
Legal counsel, yeah.
Legislative council drafts the legislation. Sorry, actually, I'll ask you to speak to it. Why yet? You'll have to go to the department officials, not to the clerk. The clerk drafts the amendments and determines if they're admissible. The question you have would have to be addressed by department officials.
Thank you for the question. In our work on the Canada Disability Benefit, we do expect, and the minister did talk about this at committee, that there may be interactions with other federal programs as well as provincial and territorial programs, and she made it very clear in her testimony that the intention in terms of the design of the benefit would be to ensure that it does not interact with those programs, that there are no negative interactions or clawbacks of those programs. So in the sense of this amendment and what's being proposed here, maybe I'll take it in that backwards order from which the member asked the question in terms of provincial and territorial, their interactions with their provincial income tested programs. That would be the only way to ensure that would be through their legislative, regulatory, or policy processes, and there are an array of those for each of those different programs. It's different. But really would be under the authority of those governments to be able to make those changes to their legislation to determine how to treat this new benefit. In terms of federal programs, we do foresee that there could be some potential interactions, but it will really depend on the design of the benefit. And so if there are any consequential amendments that would need to be made to provincial or to federal, programs, they would be done so through legislation, regulatory processes, or policy. Again, it depends on each program, but would not necessarily through the intention of this clause, which was really intended to speak to issues of bankruptcy and insolvency, so that the CDB would not be used as a way to pay outstanding debts.
So just to clarify, this amendment as written would not protect any clawbacks from provincial and territorial partners, because that would be something that the provinces and territories themselves would have to write into their own legislation. Is that correct?
That would be my understanding. I'm not a lawyer, but I would imagine that it would need to be done through the legislative, regulatory, or policy frameworks of those governments, not the federal.
This really would be, as the minister had proposed, this would be the minister negotiating with each province and territory and making sure that she negotiates no clawbacks with the provinces and territories. So as the current bill, as it exists currently, that would provide the minister the authority to go enter those negotiations and seek and negotiate no clawbacks at the provincial and territorial level. Is that correct?
That's correct, and it would be consistent with, for example, the Canada Child Benefit, which is a similar situation.
Okay, terrific. And then in terms of federal interactions with any negative interactions with existing federal programs, that's something that, in your opinion, is not something that should be fixed through this framework legislation, but it's something where the legislation supporting those other federal programs, that's where you make the alterations and the changes. Is that correct?
That's correct, and
Okay.
the timing of that would be important to do after the design of the benefit is set, so to understand the interaction with those programs.
So first, in terms of process, the first step would be to work together with the disability community on the regulations, get the design of the program in place so we understand how the program is designed, and then we could look at how it impacts or interacts with other federal benefits, and at that point is when you make changes to those benefits and that legislation to ensure that there are no clawbacks. Is that correct?
That's correct, and that's the process that we're following.
Okay, great. Thank you very much. Thank you.
Madame Chabot and then Ms. Gray on the amendment.
Je vais avoir une question.
I would like to have a question either for the movement or to our analysts. I had read this. I was in favor, at least interpreted liberally, because this is about Section 9, accessibility. And it says that any benefit for a person with a disability is not subject to the operation of any law relating to bankruptcy, and secondly, cannot be assigned, charged, etc. 3, cannot be retained by way of deduction, sought off, or compensation on the Act of Parliament, and it is not garnishable, because a clawback means you cannot garnish on a benefit already received, and it means that one cannot touch that federal portion of the Canadian disability benefit in application of an act of Parliament, not a provincial legislation. So I'm trying to understand why this is so complicated. I felt that there was some logic there. And if it isn't logical, please explain it to me so that I am voting in the right way. Thank you.
Ms. Wilcox?
Thank you. If I understand the question correctly, I think that, and I'm not fully understanding what the member that introduced the amendment and their intention. We would not read this as that it could prevent. It would direct other programs and their legislative frameworks. So for example, we would, if there is an interaction with another federal program, such as, for example, the Old Age Security Program, that program would require an amendment to its legislative framework that would exempt this benefit from, if it was to be not included in the calculation of income for that program. In terms of what it is trying to do, again, the intention is to ensure that if there is if the individual is in a bankruptcy situation or has debts against another program, that this is not being clawed back. Again, because it is a poverty measure, we're trying to protect the individuals that receive this as such, and it is similar, I think, to the Canada Child Benefit in that regard.
Ms. Gray and then Mr. Van Bynen.
Thank you, Mr. Chair. Well, I think regardless of what the minister's intentions might be, we have to go with what we have in legislation. And as I mentioned, this is for relating to clawbacks. We heard that a lot from stakeholders and from people that had reached out, a big concern of theirs. This is for within federal programs. We know that at this point that interaction with provincial programs would have to be negotiated, but especially since a lot of this again will be done in regulations, it's really important that we put in legislation something to this effect. And we just heard from the officials that there could be interactions with other federal programs, and so this is so that we don't pass the buck down the road. We want to have a clear message right now from the start that there is no clawbacks, or the intention is for no clawbacks, and those won't occur. And so putting this in here sends a real clear message that that's in fact what will happen. And I think we all agree on that that's what the intention is, but it's not to push it off down the road, and to make sure that we actually have it in the legislation. Thank you, Mr. Chair.
Thank you, Ms. Gray. Mr. Van Bynen, then Mr. Long.
Thank you. Mr. Chair, this section, the payments that cannot be charged, the intent of this section is to protect the benefit to the recipient, and so that others can't, encumber it by garnishee or anything else. And the only way I understand that the clawbacks actually took effect was when the provinces reduced their support once they saw the federal support coming up. So I'm wondering how this amendment would deal with that, particularly if the clawback is within the domain of the province and not within the domain of the federal government. If I could get clarification on that.
Ms. Wilcox or Mr. Conrad?
Thank you. In fact, I don't believe that it would serve the intended purpose. What would need to be amended in other legislation is how income is calculated, and it would need to be specifically exempted in that legislation to specify that income received through the Canada Disability Benefit would not be treated as income for the purposes of the calculation of those benefits. And that would be the same at the provincial level as well as at the federal level. And most of those legislation are quite specific in what they use to determine income. And so we would require a consequential amendment to exempt this as income for any of those programs.
Mr. Long?
Thanks, Chair. I'm just struggling with the word recovered. I think the first question, if I might, through you, is to MP Gray. Like, do you think it's a clawback? Is that what you're worried about? And my question to the officials too is, what's the meaning of recovered to you? How do you interpret that? I'm just struggling with the recovered. Is it like, so I guess my first question would be to MP Gray. Thanks, Chair.
Thank you, Mr. Chair. So again, we have really clear what our intention was, and this is wording that legal came back with. And so that was wording that they came back with that would be the appropriate way of capturing that. Apparently, you can't say, we don't want to have clawbacks. Like, that's not a legal thing that you can put into legislation. And so the wording of this came from legal, and they knew the intention, and this is the wording that they came back that would be appropriate for this legislation.
Chair, I would ask then if legal could clarify their opinion. I mean, like, legal? Again, it's recovered that's the struggle that we struggle with.
You can speak to it, but you can't.
Thank you, Mr. Chair. Legislative clerks, we do not draft amendments. It would be the Legislative Council who drafted the amendment, so we do not have an opinion on the legal content of it.
Did I miss anybody else?
But why was it allowed then? If you can't, like,
It's deemed admissible.
Procedurally speaking, it's admissible.
Okay.
It doesn't go against any procedural rule.
Do you want the floor, Ms. Gray?
Sure, Mr. Chair. Well, I'll just say that this amendment, that the committee members have known about this amendment. It's not something that I've just tabled right now. So committee members could have had legal advice on this prior to the committee meeting today. So I think I've answered it based on where our intention was and what came from legal. Thank you.
Mr. Kuzmerchek and then Madame Zarillo on the amendment CP1.
Yeah, I mean, I think that there is a unanimous consensus here around committee members that we want to prevent provincial and territorial clawbacks. That is something that we've heard from witnesses here. I think every committee member has made the same comment here. We know that it's a priority. We heard the minister come here and talk about making sure that when the Canada Disability Benefit is introduced, that Canadians with disabilities are better off, that this will supplement existing programs. And so that was loud and clear. And I can tell you that everybody around this table shares that goal to make sure that there are no provincial and territorial clawbacks. What we heard from the officials right now is that the way that this amendment is worded that it will not actually protect against provincial and territorial clawbacks, that in fact protections would come from negotiations between the minister and the premiers and the provincial and territorial partners. And so that's what I'm struggling with right here, because I see the intent of it, the spirit of it, I think is admirable, but we heard that it will not actually provide that safeguard. And the other question that I do have for the officials is, again, on that word recovered, because what we really don't want to do here as well is we don't want to have unintended consequences here. And so I wanted to ask our officials, I understand that the legislative clerk is not able to comment on that and interpret the word recovered. So maybe perhaps I'll ask our officials to speak to the word recovered here. Are there other instances where the word recovered is used in a way that maybe we don't intend to use it right now? Are there concerns around that, the way that word is being used and the way that amendment is structured?
Fox?
Thank you, Mr. Chair. I can't speak to how recovered is used in other legislation. What I can say is that it may be contrary to Section 9D, where we are trying to, for the purposes of family orders, make the CDB garnishable. So if there is a parent, for example, not paying their support payments to another parent, that this would be a benefit that could be used to recover that money. So there may be an interaction between that word recovered and that particular clause in terms of an interaction. And then in terms of clawbacks, what I would say is that when we talk about clawbacks, it's a bit of a word that we use, but we haven't really explained it. But it really is the calculation of income for those benefits. So whether or not the new benefit, the Canada Disability Benefit, would be put into those legislation for those other benefits to be used for the calculation of income. And that's what really we're looking at when we talk about the clawback, is to exempt this benefit for the purposes of the calculation of income, and that's the clawback that we're speaking about. So it really would require a specific legislative amendment to those programs in order to protect that.
One more question. Yeah.
I just wanted to bring the conversation back to 9D, because I think you raised a really critical point here about unintended consequences of having this amendment introduced. And 9D says, a benefit under this act is garnishable monies for the purposes of the Family Orders and Agreements Enforcement Assistance Act. And there may be some conflict here. So can you just explain that one more? Because I think it highlights what we're concerned about here, which is that there may be unintended consequences here. If you could speak to that a little bit.
Yeah, indeed. So this again is consistent with the Canada Child Benefit, for example, where it is garnishable for the purposes of family orders and agreements. And without this addition in here, you wouldn't be able to use the benefit to pay if a parent wasn't providing the support payments that were required under law, that they would be required to pay. The one other thing about recovery that we would just specify is that normally this is dealt with under provincial common or civil law and not federal statutes. So that's another element that is different in this situation.
Madame Zarillo, then Madame Shabat on the amendment CPC 1.
Thank you. And just with this new information, I have a question about for federal benefits. How many federal programs or benefits would potentially interact? Those acts, how many acts are we talking about here that would need to be changed?
Yeah, Madame Wilcox.
Thank you for that question. It's an excellent one, and I can't answer it at this point. But what I could say is that when we have the design of the benefit, what we will do is look at all of the interactions of all the federal benefits to see how this will interact. And the reason why I can't specify at this point is because without the level of the benefit, without the income thresholds that we would be using, without the reduction rates that would be applied, without the population that we're talking about established, it would be very difficult for us to fully assess the suite of federal programs that could potentially interact with this program.
Madame Madame Zarilla?
And I had one other
Yeah.
question on the gender lens and the GBA. So, I mean, like I said, the new information today around the child benefit, I'm thinking about those whose spouse has passed away. I'm just wondering, is there more of an impact on women on this one?
I don't have the figures in front of me, but certainly I think from my recollection that there are more women who receive family orders, for example, in terms of family support payments than there are men. But I could certainly get that information for you to better understand what those figures look like. But likely this would be the more for women than men.
Madame Shabbat, and then I believe Mr. Kuzmarchuk. Did you have your hand up? Okay. Madame Shabbat.
Notre première lecture, il y a
My first reading and analysis appear to me simple and logical, but clearly, in my view, from a legislative point of view, I see a difference between clawing back and recovering. These are completely different terms. Under law, that is very clear. So I'd like to look at an example. That is the Guaranteed Income Supplement. So that Guaranteed Income Supplement, and again, I'm retired, but let's say if I were retired, would it be exempt from recovery under federal legislation? Because here we're saying, and I apologize for my reading of it, but we're not speaking about the provinces. There's a difference between saying, on the one hand, that the minister said that she wanted this new benefit to be added to, that it be a complement to, etc. In fact, we'll be speaking to that when we come to the next amendment. But in this particular case, you cannot claw back money and you cannot recover, rather. There's a difference in my mind between those two. Recovering means that in the case of fraud or if something occurred, I would not be able to recover that amount. That's what it means, and it's somewhat more cumbersome. So we would need to see examples because this is about federal laws in application of federal legislation other than this act, that is an act of Parliament other than this act. But again, we would need some legal opinion from experts. Mr. Chairman, I'm not a legal expert. I did study law when I was young, but I understand something about procedure, but I think it's important to get the legal sense of this. But as Section 9 stands, that's fine. It cannot be retained, etc. But I was ready to state that it was fine, but here we're speaking about recovering. And we need to clearly understand this. There's something that isn't quite clear here.
Excuse me. Thank you, Madame Shabbat. Does Ms. Wilcox, you care to comment on her comment? It's and we have officials from the department and we have legislative counsel, but they simply comment on the admissibility, not the interpretation. Am I correct? Yeah. So we'll go to Mr. Kuzmarchuk, and then Ms. Gray has her hand up. So if members can choose as they choose, but you have the amendment. The amendment was deemed as admissible. It's on your discussion, and then eventually we'll get to a vote. Mr. Kuzmarchuk.
Well, thank you, Mr. Chair, and Madame Chabot, thank you so much. You much more eloquently described the confusion that I think we have with the amendment as stated. That was our confusion from the very beginning. The word recovery to us connotes a recovery of debt, for example. And in situations where, for example, there may be a payment made to someone that was not eligible, for example, or maybe in situations where there's identity fraud, that's where the term recovery, as I understand it, is used. That is completely different from the goal of protecting the Canada Disability Benefit against clawbacks. So recovery is debt, clawbacks is making sure we're not reducing. And so I think that's where the confusion stems from. And the danger of that confusion, as the amendment is currently written, is, as the officials have stated right now, the confusion can have unintended consequences and can impact families and disproportionately impact children and women. And so I think we have to be very careful about this amendment. I think we all share the spirit of wanting to prevent clawbacks. I don't think this amendment is the vehicle. And so I ask, Mr. Chair, I actually ask for a moment for us to suspend the meeting just so we can have a discussion about this if possible. Thank you.
Suspend for a few minutes. Zoom, and the floor is Ms. Gray's.
Thank you, Mr. Chair. I just wanted to comment that if we actually look in this legislation, which talks about the regulations that will be implemented around this legislation, if we look at 11P, it says, respecting the recovery of overpayments and debts due to Her Majesty in right of Canada, including limitation or prescription periods. So it basically what this is saying is that will be developed in regulations. And so what we're saying is this is so important that we want to take it out of that part saying it will be solely developed in regulations and actually put some wording in the legislation. And so that's what it is. And so you can see right there that the wording is actually recovery of overpayments. That's so the question, it's not to replace. It's just making sure that we put some wording in there just to draw it into how important it is that we make sure that it's actually in the legislation itself. So I just wanted to draw everyone's attention to that. Thank you, Mr. Chair.
Thank you, Ms. Gray. Any further discussion, Mr. Kuzmarchuk, on Amendment CPC 1?
Mr. Chair, I think we're all just trying to wrap our heads around this particular amendment. Again, there is confusion around it. It's not clear, and again, there's concerns about unintended consequences. I do wonder if it's possible. Could we just skip this amendment, because I know we have a lot of work ahead of us, and could we skip this amendment and come back to it either later today or at a later date and seek legal opinion on this? I just think this is so critical. And again, we share the spirit of no clawbacks, but this particular amendment here may be problematic and may cause unintended consequences here because, again, it's not clear.
The committee can, by unanimous consent, suspend all of Clause 9 and then return to it.
Can we suspend for just 1 minute, Mr. Chair?
Yes.
Thanks.
Suspend for a few minutes. Ms. Gray?
Great, thank you, Mr. Chair. We'll push this one aside for a little bit while we work on other amendments.
So the formal part, we have to get unanimous consent to suspend all of Clause 9 and return to it before the end of the bill. Do I see unanimous consent to suspend Clause 9? Okay. Clause 9 is suspended. Shall Clause 10 carry? Carried. Clause 11, PV 6. It's deemed moved. Mr. Morris?
Thank you, Mr. Chair. This is the first of several amendments being proposed by several parties with respect to how regulations will be made. And this first one replaces 11D, which currently says that the governor in council may make regulations respecting the manner in which a benefit is to be indexed to inflation, replacing that text with that it would require a benefit to be indexed to inflation and respecting the manner in which it is to be indexed. We heard and read many briefs and heard from many members of the disability community who called for indexing to inflation to be more clearly articulated in how regulations would be made. And certainly as an MP from Ontario, where ODSP is not indexed to inflation, recognize that there are members of my community who have not seen increases to their existing disability supports for some time. The intention of this amendment is to address that in the Canada Disability Benefit. Thank you.
Any further discussion on the amendment PV 6? Mr. Kuzmarchuk?
I just wanted to say that, again, wanted to thank my colleague. Excellent recommendation. It clarifies the bill and provides additional clarity as well too in terms of making sure that the benefit is indexed to inflation. It's something that we heard very clearly from so many witnesses that came before the committee, and so we will be supporting PV 6.
Sure.
Ms. Gray?
Thank you, Mr. Chair. We thought that this was a good recommendation as well, and we'll be supporting this.
Shall PV 6 carry? PV 6 is carried with unanimity. PV 7.
Thank you, Mr. Chair. And if I could start just by saying thanks to my colleagues for their collaborative approach to this process. PV 7 is similar with respect to item F of how regulations are made. Currently, it says that governor in council may make regulations respecting applications for a benefit. The new text of PV 7 would change that to be respecting applications for a benefit, including regulations providing for an application process that is without barriers as defined in Section 2 of the Canada Accessibility Act. This follows the recommendations from many of the organizations that we heard from that are calling for the Canada Disability Benefit to be as accessible as possible, that it might be ideally even automatic when a person might file their income taxes, and this would encourage in the recommendations for that accessibility to be put front and center, following again calls we've heard from many organizations, including the Accessibility of Ontarians with Disabilities Act Alliance and the 25 signatories to their letter. Thank you, Mr. Chair.
Mr. Kuzmarchuk?
Well, thank you very much, Mr. Chair. And again, another excellent amendment suggested by my colleague. Goes to show teamwork makes the dream work. I did want to just raise one small flag and perhaps ask for a friendly amendment if that's possible, which is if the amendment can refer not to the Canada Accessibility Act, but to the Accessible Canada Act. Which is, I believe, the act that my colleague was seeking to reference. And so if we can just, again, change it from the Canada Accessibility Act to the Accessible Canada Act, that would be terrific. And I'm not sure if we need a motion or a amendment or...
We'll see what the discussion is.
Do I get to... I certainly see that as a friendly amendment.
Madam Clerk, Do we need to deal with it separately? If there's unanimous consent on a minor change, the committee can agree to sub-amendment. So I'm seeing unanimous consent unless somebody objects. So that was accepted. Mr. Kuzmarchuk, now we'll vote on shall PV 7 carry as the minor amendment. Oh, Ms. Gray.
Thank you, Mr. Chair. I just wanted to comment that that it absolutely makes sense to have this in here. It's too bad it wasn't in the legislation previous, because it definitely makes sense to make sure that that the application process is accessible and barrier-free. Thank you.
Okay, again, shall PV 7 carry as amended? Seeing no dissent, PV 7 carried with the minor amendment unanimously. PV 8.
Thank you, Mr. Chair. And again, thanks for the spirit of collaboration from across all members of the committee. PV 8 seeks to address the concern we heard with respect to looking at an individual's income as opposed to a household. And so the text I'll read out, it adds line 39 to page 5, adds 1.1, the eligibility criteria, conditions, and amounts provided for in regulations made under paragraphs 1A to C must be determined on the basis of the net income of the person to whom an application for a benefit relates, not to the income of the person's household. And again, we heard from many witnesses, both who gave testimony here and wrote in written briefs with respect to ensuring that the benefit looks at the individual and not a family. Thank you.
Any further discussion on PV 8, amendment PV 8?
Chair.
Ms. Cirillo and then Mr. Long.
Thank you, Mr. Chair. And I was wondering if I could ask either Madam Wilcox or Mr. Conrad today. I did see some consultation that was done. We just got some information last night in regards to consultations that were done as early as January 2020. And there was some consultation around this and from diverse communities that had different points of view on this. So I just wanted to, because it's relatively new information that we just received, I wonder if we could get some information around what the concerns have been heard in relation to diverse communities.
Thank you, Mr. Chair. So this you're right, this has been a subject of discussion. The eligibility behind the benefit is key in how we would determine how much someone got and on what basis. There is a school of thought that says we should absolutely go in this direction. There are other voices saying be careful and engage us and understand better. Back to the comments around unintended consequences. Most federal benefits are built on family income, individual income. You could end up, for example, with a couple where there's a 1% income earner, and the other partner has a disability. You would be paying the benefit, therefore, to a high income family, but based on the individual income. So it's those kind of scenarios that, as part of we've heard about from the community, and is actually a lot of the work that needs to be done through the regulatory process, which we had foreseen this being part of the regulations rather than the legislation, to understand the exact design that works best to make sure we target the people who need the help the most. So that's something I think that we have heard from the disability community, but I think their expectation is that we will work with them through the regulatory process to establish this. And that's how I think the bill was designed and how the community would expect us to do it.
Mr. Long, then Madame Shabbat.
Yeah, I guess, Chair, we're kind of coming from, I understand where MP Moore's what he's saying here, but I mean, I think it goes beyond the concept of the legislation to determine the specific element of eligibility. And like Mr. Conrad just said, I think through the regulatory process, obviously there's going to be consultation with the disability community to kind of determine the best way forward there. So I think that kind of boxes it in too early. So we can't support that.
Madame Shabat and then Mr. Kuzmarchuk.
Merci.
Thank you. As Mr. Morris indicated, it's true that we heard viewpoints saying that this benefit needs to be individualized. And from these individuals, we understood the school of thought behind that. It's about their independence, about their situation. As a result, these persons need to be supported. I had more of a technical question. It's a net revenue compared to gross income. Sorry. However, there are other viewpoints, and sometimes it is a good thing to look at it as a family household and see if that's beneficial. So which would be the formula that would be the most beneficial for the person who has a disability? That's the person we want to help. Am I ready to say that the best formula would be based on the individual's income? There are arguments in favor of this. Or perhaps we could continue that during a discussion. However, if we want to respect the principles here.
Mr. Kuzmarchuk and then Madame Zarello.
I think for me the most important principle is the principle of nothing without us. And in my opinion, that this conversation about individual versus family, it's better suited, as the officials had stated. This is something that needs to be discussed with the disability community. Listen to their viewpoint, listen to their voices. And I think this is why, again, I will oppose this amendment because, again, it presupposes that conversation and that consultation, which is so absolutely critical. And I think we need to hear from the disability community on this very issue, and we will when this bill moves from the committee and moves to the House and passes. Those consultations that will take place, those discussions with the disability community, it's exactly where we will determine which avenue that we will take. So for that reason, I will be opposing this amendment.
Madame Zarello, you had your hand up.
Thank you, Mr. Chair. And I actually, I think this is one of the things that we did here in testimony was that the community wanted to be fully involved, wanted to be fully engaged and fully at the table. And I know that, there is some testimony here and some consultation here that just talks about racism in the application of benefits. The lack of consultation on that is clear, and I think that precarious immigration status, citizenship status, all of those things need to be considered. And I want to hear from people that persons in the community that would be affected by this before we make a decision. So I am open to that idea that we need to have more consultation before we usurp it here in regulation.
Mr. Morris?
I just feel my colleagues have made great points, and I'll offer to withdraw the amendment.
So what is the wishes of the committee on PV 8? Withdraw?
Yeah.
Okay.
Yeah. Scratch.
Okay. We need consensus to withdraw, or we have to vote. Do we have consensus to withdraw? Yes. Okay. The PV 8 is withdrawn. We now move to NDP 3. Ms. Cirillo?
Thank you, Mr. Chair. And as I had stated earlier, it was heard over and over in testimony, and basically almost every testimony that we either received in paper or spoken was that people wanted to have an adequate standard of living and that to have the necessities of life, and we know that's also our commitments as Canadians. So I wanted to raise here again the concept of adequacy because unfortunately at this point in time we could not get it into legislation. We could not get it secured that the minimum floor would be the poverty line, and of course we know that persons with disabilities need even more than the poverty line because expenses can be even higher. So here I am introducing the idea that it goes here into regulation to at least protect the minimum that the minister and the ordering council should be considering for this benefit. So the concept of adequacy was raised in testimony by human rights lawyer Vince Calderhead on Monday, 14th of November, and the Canadian government has legally binding obligations under international human rights law to ensure that persons in need have an adequate standard of living. Canada ratified the UN Convention on the Rights of Persons with Disabilities, as well as acceded to the optional protocol in December 2018. And under this convention, we adhere to the principles mentioned in Article 3, which include, among other, non-discrimination and accessibility. Article 28 declares an adequate standard of living and social protection for persons with disabilities, specifying the need for ensuring access by persons with disabilities, in particularly women and girls with disabilities and older persons with disabilities, to social protections and poverty reduction programs in paragraph B. Furthermore, as it has been mentioned in testimony, under Section 36(1) of the Constitution Act 1982, Canada and the provinces have a joint constitutional commitment to provide essential public service of reasonable quality to all Canadians. Canada's official poverty line, and we actually have one, so I'm surprised that it's not being used in this legislation, reflects the cost of baskets and goods services representing a modest basic standard of living. And even StatsCan themselves agree that it's ableist in its nature, that it does not cover the costs of disability, which we have talked about in the past, but at least this is a minimum protection for people. And lastly, I will say for Parliament to meet its international human rights obligations and constitutional obligations, Bill C-22 must be amended to include a provision which requires that amounts set by regulation for the Canada Disability Benefit be adequate. And I will just say that it was testimony from Vince Calderhead, the Maytree brief, Canadian Human Rights Commission brief, the Arch Disability Law brief, Michelle Hewitt from Disability Without Poverty, Income Security Advocacy Centre brief, Basic Income Canada Network brief, Jeff Nevin from Indwell Testimony, Alliance of Equality of the Blind Canadians brief, Rosemary Hamelgarn Testimony, Lorna Aberdeen brief, just to name a few that believe that we should be protecting for a level of adequacy. And I really, truly had hoped that we could get this into Clause 5 in legislation, because this is a matter of life and death, Mr. Chair.
Thank you, Madame Cirillo.
Oh, and I'll just take the opportunity to read the amendment. The governor and council must assure, you okay, Mr. Chair?
Yes.
The governor and council must ensure that persons with disabilities from diverse, in making 1.1, in making regulations under paragraph 1C respecting the amount of a benefit, the governor and council must take into consideration the official poverty line as defined in Section 2 of Poverty Reduction Act. Thank you, Mr. Chair.
Thank you, Madame Cirillo. Mr. Long?
Chair,
the amendment.
yeah, I thank MP Cirillo for this. It's a good amendment. Obviously, the intent of this is to lift persons with disabilities out of poverty, and we can definitely support this. Thank you.
Ms. Gray?
Thank you, Mr. Chair, and I also believe that it holds to the intent of this legislation, and this is something that we can support as well.
Okay. Do we have consensus, unanimity on NDP 3? Yes. Seeing no dissent. NDP 3 carried unanimously. NDP 4, Madame Zerillo.
Thank you, Mr. Chair. And actually, this goes back to a conversation we just very quickly had about Nothing Without Us. So in much of the testimony, we did hear about the opportunity for co-creation. And although in the preamble, it includes some language about Nothing Without Us, this is an opportunity for us here around this table to amend the bill to require the government to meaningfully involve and include persons with disabilities in the development and design of the Canada Disability Benefit Regulations. And this provision should specify that meaningful participation must be fully accessible, ongoing, and allow for two-way dialogue directly with decision makers, and is inclusive of diverse communities of persons with disabilities. And I'll just say that this was also shared in Maitre brief, Disability Without Poverty in their testimony and brief, Arch again with their brief, Inclusion Canada in their testimony and brief, and Lorna Aberdeen in their brief. And if I could just read the amendment, Mr. Chair. So we're looking for in Section 3 that the Governor and Council must ensure that persons with disabilities from diverse communities and a range of backgrounds are afforded a meaningful opportunity to collaborate on an equitable basis in policy development leading to the making of regulations under this Act. And that 4, the development and making of regulations must enable full effect to be given to the principles set out in the preamble regarding engagement with the disability community. Thank you, Mr. Chair.
Any further discussion? Mr. Kuzmarchuk, we're on NDP 4.
Yes, thank you, Chair. If I can just ask for a brief suspension.
Why not? Suspend it. We were in discussion on NDP 4. Any further discussion on NDP 4? Ms. Gray?
Thank you, Mr. Chair. We really appreciate and like this amendment, but there's another one that's coming up shortly that actually is very similar. That we would be more apt to support just because the wording is a little bit more encompassing. So I just wanted to say that that's sort of where we're thinking of going, and that would be the rationale, because if that other amendment wasn't coming up, then we would support this, but because there's this other amendment coming, it makes sense.
Mr. Kuzmarchuk?
Yeah, thank you, Chair. And I wanted to appreciate the comments that MP Gray made as well, too. We're in total agreement. We support the spirit of this particular amendment, which is, NDP 4. But we feel that PV 9, is it? Is the one that is, I think it's more succinct. And also more encompassing as well, too. And so, again, we would prefer to support the amendment that's being brought forward by Mr. Morris.
Okay, seeing no further discussion, then we will vote on, I don't see unanimity, so we will ask the clerk to call a vote on NDP 4. Ms. Cirillo?
I just want to make sure that I just have one closing comment, which is just on, the wording around meaningful opportunity was something that we heard from testimony over and over again, and that's why it is in part of mine. And this is from Matry, Disability Without Poverty, Arch, Inclusion Canada, and Lorna Aberdeen. And then I would also just like to say that the development and making of regulations that must enable full effect to be given to the principals was important. Thank you, Mr. Chair.
Thank you, Madame Cirillo. Clerk, who called a vote on NDP 4.
The vote is on NDP 4. Mr. Long.
Oppose?
Madame Martinez Ferrara.
No.
Mr. Collins.
Opposed.
Mr. Kuzmarchuk.
Opposed.
Mr. Van Bynen.
Opposed.
Ms. Gray.
Opposed.
Mr. Melillo.
Against.
Mr. Jennifer.
Oppose.
Ms. Ferrari.
Oppose.
Madame Chabot.
Pour.
Ms. Cirillo.
Yes.
That's 2 yeas, 9 nays.
NDP 4 is defeated. We'll now go to shall clause 11 carry as amended. Agreed? I see thumbs up. Okay, seeing no dissent, clause 11 is carried as amended. New clause 11.1. NDP 5, Madame Cirillo.
Thank you, Mr. Chair. And this is in regards to transparency. As I was mentioning earlier, we took very seriously here the nothing without us, but we did want to make sure that there was transparency and that there was in the process a good opportunity to have oversight, because the current government is a minority government, and that needs to be respected. and other parties must be allowed to approve or disapprove regulations that we won't necessarily have any ability to see. So as an important component to Canada's democracy, transparency must live throughout these regulations. So this amendment is providing the opportunity for other parties to have oversight on the regulation, to hold the government to account, and for the Liberals to have the best support to deliver a CDB from Parliament that's good for persons with disabilities currently living in poverty. So based on the testimony that we received from Accessibility for Ontarians with Disability Act Alliance, the Canadian National Institute for the Blind, Accessibility for Ontarians with Disabilities Act Alliance, Citizens for Public Justice, and Professor Jinyan Lee from Osgood and Kate Chung in correspondence, amongst others, the amendment proposes that the minister will table a regulation that has already been made. We'll make sure to table a regulation before it is made to this House. So if you don't mind, I'd just like to read through the amendment. So this is for Bill C-22 has been amended by adding after line 3 on page 6 the following new clause around tabling of regulations. 11.1.1, the minister must cause each regulation that is provided to be made to be tabled in each House of Parliament. 2, a regulation may not be made before the earliest of, and then there's a number of options. A, 30 sitting days after the proposed regulation has been tabled in both House of Parliament. B, 160 calendar days after the proposed regulation has been tabled in both Houses of Parliament. And C, the day after the appropriate commitment of each House of Parliament has reported its findings with respect to the proposed regulation. 3, the minister must take into account any report of the committee of either House. If a regulation does not incorporate a recommendation of the committee of either House, the minister must cause to be tabled in each House of Parliament a statement of the reasons for not incorporating it. A proposed regulation that has been tabled under, 4, a proposed regulation that has been tabled under subsection 1 need not be tabled again before the regulations is made, whether or not it has been altered. And 5, for the purpose of paragraph 2A, sitting day means a day in which either House of Parliament sits. And I will just say for my colleagues here, one of the key things here is that this amendment will allow other parties to see regulation before they become regulation. Thank you, Mr. Chair.
Thank you, Madame Zerillo. Before we go into discussion, I want to clarify with the committee that amendments NDP 5 and BQ1 both seek to have the minister table regulations that the government proposes to make. Members of the committee should keep this in mind when debating and voting on these amendments in order to be coherent in the bill. So just keep that in mind. Did you have? Okay.
I got a question. Or no?
I believe Madame Shabbat had her hand up first, and then Mr. Long and Mr.
Merci.
Kuzmachuk.
Merci.
Thank you, Ms. Zerillo, for this amendment. If you look at the next one, which is from the Bloc Québécois, you might find similarities between the two, but there is a fundamental difference. First of all, we are dealing with NDP. I'd like to move a sub-amendment to NDP 5, which would read as follows. Madam Clerk, you should have received it because you required that we table this in writing, the sub-amendment. Add to 11.1c a 3 in parenthesis 3 that the regulation can not be tabled if the House of Commons adopt a motion which rejects this amendment. So it cannot be taken if the House of Commons adopts an amendment which, I'll repeat it in English. Otherwise, if I'm not going to say it in English, it will hurt your ears. But I believe that you should have received the sub-amendment in both languages. what is before us, and I think since the very beginning, is that we are seeking to respect a process which stipulates that regulations must be tabled on the basis of the principle nothing without us for persons with disabilities. But what was a first in this particular bill, and really it's unusual and it's been said here, is that parliamentarians are faced with a blank page. Yes, and governments have the authority to issue regulations, and when it comes it's usually about more administrative issues and not such fundamental issues, so-called fundamental issues as the eligibility criteria for benefits, as the conditions under which we will issue this benefit and the amount of the benefit. This language in a democracy is something for all of parliamentarians because it also triggers costs for members. So we believe that regulation can play out by and for persons with disabilities. But to date, because we believe that your amendment by NDP doesn't have enough teeth, so we could table a report. If we don't agree, we can state we're in disagreement because there are reasons. And now we, however, taking up that power to either adopt or deny this draft amendment, to defeat it. And we will not have to do this for the entire regulation, but for specific points, 7.1, 8. ABC, but the NDP is targeting the entire regulation amendment, so we won't change it. But that is the spirit underlying this. It's the intent. The idea is to ensure that the House of Commons can adopt this draft amendment properly. And hopefully we'll be happy if all goes well, but I think it behooves us. This is a never-before-seen situation that is a result that will not be subjected to the adoption by the House of Commons. Is that clear for everybody? Thank you.
Okay, currently we have a sub-amendment that has been moved by Madame Chabot. I'm not sure if all members have a copy of the sub-amendment. It was just emailed to you, I'm told.
I was just going to ask for a copy of it. So it was just emailed to us?
Okay.
Can we suspend then?
Yes, well, yes. You need to have time to consider the sub-amendment. We'll suspend. We're now back in committee, and clerk, bring me back to where we were. We had a sub-amendment on the floor of Madame Chabot, a sub-amendment to NDP 5. It was circulated. Mr. Long, Mr. Kuzmarchuk, on the sub-amendment.
Thank you, Chair. And through you to the officials. I mean, look, time is of the essence here, and I mean, we heard witness after witness and submission after submission talk about how urgent it is for us to move this along. So my question to the officials is, can you give us an opinion on timing if this could delay delivery?
Thanks.
Mr. Conrad?
Mr. Chair, I'll just maybe if it helps, just remind members that the process once both houses are finished consideration of Bill C-22, if it indeed passed, we will then do the regulatory process. That will take, a length of time, particularly with the level of engagement that is built into the legislation now, but expected by the minister and consistent with nothing without us. When we get through that, we'll take time. The minister has talked about that time. That's counterbalanced with, as the member mentioned, a lot of pressure to get this benefit out the door tomorrow if we could. So when we put another step into the process for whatever the rationale is, which I won't speak to, it naturally does delay. Like a one-day consideration in the House would delay the benefit by a day. It's just the nature of that. One of the areas I would just mention is when we talk about sitting days, obviously we do not have any knowledge of how long Parliament will sit for or what the legislative priorities will be. But that it is possible that even 30 sitting days could slip the benefit by literally months if Parliament is not sitting.
Yep.
And if there are other steps built into the process, if along the lines of the sub-amendment, then that would be another step in the process, which would take longer. So I'm not offering an opinion on the merits of the amendments themselves. I'm just explaining that every single step does add, and the steps that you're talking about conceivably, depending on Parliament's consideration, could add a significant amount of time till the benefits delivered.
So I guess the concern in particular would be I'm just looking down, Ms. MP Zarello's, the 160 calendar days. Is that, like that could delay it in a major way, correct?
Well, that's over 5 months, I think, of an inevitable delay because it will slow it, and whether that's less or more than 30 sitting days, I don't know, but that is a real time that will.
And I mean, yeah, just to reiterate again, I know everybody around this horseshoe wants to get this done and get it out and get it in the hands of people that need it as quick as possible. And again, when I read through this amendment by MP Zarello, really every part of it, to me, has a major potential to delay it. And, when we have people in such urgent need for this benefit, it's just something I think that is challenging for all of us. So, yeah, again, thank you for that. I just want to try to get clarity in that. Thank you.
Madame Chabot, briefly, and then we're getting beyond the hour.
Clearly, under the argument that we must ensure that those who need this benefit, yes, that is an argument that we're putting forth. But you see, in democracy, there is a process, there's an order in government matters that behooves government. The government has decided to table this bill now. And as members and as parliamentarians, we even said this before the bill came to committee. We're asked to be entrusted with a blank page. So then to come back to the House, and that will delay the work in paying out the benefit. But in a democracy, when you draft regulations, and let's say it's a regulation to review and re-review decisions already taken, there's a portion of this regulatory work that the government can do, which is generally administrative in nature. But it's very rare that we will make a decision on a benefit or a bill that will be subject to only to a regulation that has to be adopted by the House. So I won't accept, under the argument that this might delay us by 3-4 months, that we will find ourselves in a shorter parliamentary session, that this does not deserve, as per the regulation, that members take due cognizance of the work that's been conducted to ensure that the principles outlined in the bill in terms of benefits, terms, etc., are in compliance completely, because after all, this is major for the future. This is something that we're debating now, and I think that essentially this really is fundamental, and I think that is within the purview of parliamentarians. And yes, certainly might take some time, but all the better if things are running smoothly. It will work. But that's a very minimum, in my view.
It is beyond the time, so to continue, I need unanimous consent to continue this meeting. Ms. Gray is shaking her head. Pardon?
I didn't have the translation for the regulation.
Well, yeah, that's fine. We're not dealing with it now. No. Do we have unanimous consent to continue the meeting? No. Okay.
No.
Before we go, Ms. Gray, you have a point?
Great. Thank you, Mr. Chair. And just for clarification, there were other members in here shaking their heads as well. But
Yes, I think that's
but no, I would like to, so that we can continue moving this on, I'd like to request that we have an additional meeting. And so I know that that'll have to go back to the clerk and to look into whether or not that's possible. But just so that we don't delay this legislation, I'd like to look at where we might be able to fit that in. Thank you, Mr. Chair.
Mr. Long?
Chair, I would suggest that let's look at MP Gray's request after Monday's meeting. Let's see where we're at. I have every.
Oh, I didn't adjourn it. Ms. Gray?
Thank you, Mr. Chair. Well, I was thinking before Monday's meeting. So rather than taking Monday's meeting and pushing off other business, I was referencing that we have a meeting prior to Monday in order to continue on with this work.
Okay, the clerk will check with services to see what's available. That's all we can do now because we did not get unanimous consent to continue on. So the meeting is adjourned. Thank you, committee members.